Começar normalmente com a apresentação do professor Cole e com o nosso debate, tá bom? Só esperando carregar aqui o YouTube, mas é isso. Estamos ao vivo.
Okay. Well, good morning, everybody. I'd like to, first of all, just thank Professor David Cole. For us, it's really a great honor and a wonderful opportunity to have you here, Dave. Thank you very, very much. For those who do not know him, Professor Cole teaches constitutional law, national security, and criminal justice at Georgetown Law Center and in Washington, D.C. has published a lot of articles in law journals and the popular press. He's a kind of intellectual, public intellectual for human rights in general and freedom of speech more specifically. So he joins his capacity as both a very deep and insightful scholar, and also a cause lawyer for human rights and basic fundamental rights. For us, it's really very, very interesting to have you here, David. Hate speech is a very hot issue now in Brazil. It's really very important. As you probably know, Brazilian democracy has been under attack by many social movements through social media and also in some public gatherings. And the attack minority rights under the name and under the label of protecting human dignity is something that is very common. It's very appears every day in our journals. So, and besides that, we also acknowledge the existence of a radicalization of extreme political positions, which is something that is somehow similar, parallel to what happens in the United States. And besides, the increase of racist speech is also something that happens all the time. So to protect freedom of speech, and especially to advocate for not prohibiting hate speech, it's really swimming against the tide, especially in the Brazilian context, in which I would say the mainstream ideas usually support more strict control on this kind of speech. And besides, just to point out another issue, the intense use of proportionality analysis in constitutional interpretation by Brazilian courts, and especially by the Brazilian Supreme Court, also is very challenging and creates a pattern of constitutional interpretation that is very different from the American one. So for all these reasons, it's really a great opportunity to have you here. Thank you very much. I'm really willing to hear you more. Thank you very much, Dave.
Thank you, Ronaldo. My pleasure to be here. In addition to being a professor at Georgetown, as you know, I'm also the National Legal Director of the ACLU, the sort of preeminent civil liberties and civil rights organization in the United States. So I definitely had a view on this subject, both institutionally. The ACLU has been around for 100 years, and while we defend the whole range of rights and liberties that are part of the Bill of Rights, our work around the First Amendment has really been sort of central in our history and in our identity. To take all that with a grain of salt, I'm not only American, with a particular, coming with a particular point of view, but also a particular kind of American, an ACLUer. And I want to sort of just give you a sense of sort of where the United States comes from with respect to this question of the regulation of hate and hate speech. And you know, I think the best way to understand it is through our history, and in particular through the history of efforts by the government to regulate speech. And basically the First Amendment in the United States grew the doctrine of the First Amendment, developed in response to efforts by the government to
David, sorry to interrupt you, but I have a feeling that I was listening you better before you started. I don't know if you
let me see if I put in headphones, whether it's better, okay? Is this better? Is this better or no? Yes?
Yes, it's better now. Thank you. Sorry to interrupt you.
Yeah, no, that's fine. The history of the development of the First Amendment in the United States really traces a trajectory in which the court grew increasingly skeptical of arguments by the government that speech itself was dangerous, that speech itself caused harm, that speech itself should be punished because it led to some violence, some criminal activity or the like. And on the one hand, and I think that's really, really important to understand. I think, and on the one hand, it's not obviously crazy to say, we make it a crime to engage in violence. We make it a crime to hurt other people physically. We should also make it a crime to urge people to engage in violence, to urge people to harm others. And so we did. For many, many, many years, the laws in the United States permitted the state to make it a crime to advocate crime, to advocate violence, to urge people to engage in illegal activity, was itself not protected. The court said, well, if the speech has a bad tendency, if it is likely to lead to bad things happening, things that we make a crime, you should be able to punish it, shouldn't be protected. But our history showed that authority was used time and time again by those in power to target and repress dissent, people who were out of power, people who had views that challenged the status quo, and in particular, views on the left, but not only, and in particular, but not only, communist views and ideology. And so, the argument went, the communists believe in the overthrow of the, by force and violence of the United States. They've called for it in their, doctrines. They argue for it in their newspapers. That's clearly the overthrow of the United States by force and violence is a harm that we can criminalize. We do. It's called treason. It's subverting the democratic process to try to overthrow the government by force and violence. Obviously, that's very dangerous activity that threatens the core of the country. And so we ought to be able to make it a crime for people to engage in both speech and association that is geared toward that end. And in the name of that principle, which is not I think that's, not a crazy principle. It's there's some intuitive appeal to it. We locked up thousands of people for their political associations, affiliations, and beliefs. Eugene Victor Debs ran for president in the United States from prison because he was the head of the Socialist Party. He had been convicted for making a speech in which he praised anti-war activists during World War I. That's all he did. He praised anti-war activists. He didn't even urge people to go out there and, protest the war or do sabotage, but he, talked about the courage of some of those who did. That was viewed as advocating interference with the war effort. 20-year prison sentence. 20-year prison sentence. From prison, he ran for president. Got over 1 million votes in the 1920s, not teens, I guess. And, that was upheld by the Supreme Court because we had this view that if you have a harm that can be regulated and you have speech that leads to that harm, you should be able to penalize not just the harm, but the speech, because one leads to the other. But over time, and it was really that idea that underlay all of the sort of McCarthyism, Cold War, targeting of communists for their affiliations, their associations, and their speech. And it was blessed by the Supreme Court in the 19-teens, in the 1920s, in the 1930s, in the 1940s, in the 1950s. And it got more and more, the government got more and more aggressive, more and more people were going to jail for essentially having leftist views, not engaging in violence, but having leftist views and associating with an organization that had leftist views, one of which was, it's sometimes okay to use force and violence to overthrow a country. And ultimately, the kind of the overreach that caused, the extent to which that became a temptation for the government to target those with whom it disagreed, led to a rethinking of the First Amendment and of First Amendment doctrine by the court and by the culture. And over time, the court sort of became more and more restrictive about when you could, as the government, criminalize speech because it produced harm to others, even if that harm to others could be directly regulated. And ultimately, in 1968, in a case that the ACLU argued and won in the Supreme Court, called Brandenburg versus Ohio, the court said the First Amendment protects the right to advocate for criminal activity. It protects the right to advocate violence. It protects that right up to the point at which your speech is intended and likely to produce imminent violence. So, you have to show that the person subjectively intended to produce imminent violence. You have to show that his power over whoever he was speaking to was such that they would be likely to engage in violence in response to his speech, and you have to show that it is likely to happen imminently. That is a very, very protective doctrine. It is very, very hard to convict anyone for incitement to violence under that statute. It is very protective. Why is it very protective? Because of that history. Because we saw what happened when we gave the government the broad authority to make it a crime to advocate for criminal activity. How did they use it? They used it to go after minority groups, dissidents, leftists, people who did not have power, who were challenging the status quo, who were questioning what the majority thought. And they did it in ways that really were unjustified. You should not have, the leader of a major political party spending 20 years in jail for praising an anti-war activist. And so it's really that history, I think, that informs our First Amendment, which is the danger of giving the government the power to make the move that says, because there's this harm here, we should be able to regulate not just the harm over here, but the speech that leads to that harm, And in that case, most of the cases leading up to Brandenburg, there's a whole line of cases in which the court got more and more protective of speech, more and more skeptical of this argument that if the speech has a bad tendency to lead to criminal conduct, it should be punished. All the cases leading up to that involved communists, basically, virtually every one of them. Brandenburg did not. Brandenburg involved the Ku Klux Klan. Brandenburg involved racist speech. But it was the same thing. It was speech advocating violence, just violence directed at Blacks, Catholics, and Jews, the targets of the Klan at that time. So it is really that history that I think informs our skepticism around the regulation of hate speech. I'll say a couple more things. I mean, obviously, reasonable people can differ about this, and there are plenty of democracies, yours, much of Europe, which tolerate some regulation of hate speech. In our democracy, we don't tolerate regulation of hate speech, and I think it is really because of that lesson of what happens when you give the government the power to say, this speech we're going to criminalize because it leads to this bad outcome. Everybody agrees the outcome is bad. If it's discrimination, if it's hatred, if it's violent overthrow of the government, of a democratic government, those are all bad. Hate is not worse than a violent overthrow of a democratic government, right? They're at least equally bad. So there's no dispute that those things are bad. The real dispute is about when you should be able to regulate speech because of its connection to something bad. So in our jurisprudence at this point, the idea is you can and should prohibit forceful overthrow of a democratic government. You can and should prohibit discrimination, racial discrimination. You can and should prohibit racial violence, but you should not and cannot prohibit speech that leads to that, and sort of by equating the speech with the harm, I think there's a number of arguments that are put forth in support of this notion. I'll throw out three, and then I'll talk about two counter arguments, and then I'd love to hear your perspectives and your questions. So, I think the first argument that is put forward for the importance of tolerating this kind of speech, which is otherwise, intolerable, in some sense, is the notion of the quote unquote marketplace of ideas. The marketplace of ideas is something that is easily criticized, easily made fun of. Does anybody really believe that free and unregulated exchange of ideas leads to truth? And if anyone did believe that before social media, does anybody believe it now? No. I don't think that's I think the argument is not so much this is the way we get to truth, as much as this is the best we can do. It's like what Churchill said about democracy. It's the least worst system out there. He said it much more eloquently, but the idea is not this somehow is a formula that gets us to truth. But oh my God, as between letting people express their views, debate freely, and the like, and giving a central authority the power to dictate what truth is, right? Those are the choices. Either you leave it to the democratic process, you protect people's right to say things, even if they're unpopular, even if they're controversial, even if they're hateful, because the risk of giving a central authority the power to dictate what is true, what is false, what is hate, what is not hate, what is legitimate criticism of affirmative action, what is racism. Those kinds of, giving that kind of power to a single entity is deeply problematic. It's not a way to get to truth. It's a way to lead to the suppression of any views that are seen as threatening to whoever exercises power. So that's one argument that I think is often made fun of, but I think actually makes I think if you think about it from the perspective of what's the alternative, it is a much more powerful argument. Second argument that is made in support of protecting hate speech is a kind of a combination. The importance of teaching tolerance, paradoxically, by being tolerant of the intolerant, and relatedly, affording a safety valve. That if we allow people to say what is on their mind, even if it is something we would rather not hear, even if we think it's something that should not be said, even if it's something we would never say, it teaches tolerance. And in a pluralistic democratic society, the first value is tolerance. We have to have tolerance. If we don't have tolerance, we can't survive. And I think what you're seeing today in many countries, the United States and Brazil among them, is increasing intolerance on both sides, on the left and on the right. And it's threatening the workings of democracy, in serious ways, in new democracies and in older democracies. So one way you teach tolerance is by compelling the government, the one who has the power to set the rules, to throw people in jail, compelling it to be tolerant, compelling the majority in a democracy to be tolerant. And sort of, I think the flip side of that is that it is important to have a safety valves. It is important for people to be able to mouth off. It is important for people to be able to express what they feel, because if it's suppressed, if it's repressed, it may come out in more dangerous ways. I don't know whether that's true or not. I don't know that anybody could really prove that one way or the other, but that is an argument that is often often made. And then the third argument, and I think this is actually a very powerful argument. This is to me, this is a kind of more of a pragmatic argument, but it's, I've certainly seen it in my career as a civil rights and civil liberties lawyer, for 40 years. And that is that suppressing speech because you don't approve of what it says is counterproductive. It is counterproductive because what it does is it brings more attention to the views than they would otherwise, get. It makes the speaker a martyr. There's a guy here in the United States named Richard Spencer. He's a right-wing, white supremacist. Nobody ever heard of Richard Spencer until a number of universities, having given their students free rein to invite who they wanted to come to speak on campus, and some student groups invited Richard Spencer to come speak on campus, a number of universities disinvited him, suppressed his ability to reach his audience. Suddenly, Richard Spencer became a household name. Suddenly, the Atlantic magazine, one of the great national magazines in the United States, had an entire, portrait essay on Richard Spencer. Why? Because he was the subject of censorship. Back in the day, back in the 1980s, I represented a group of performance artists in the United States who were granted, they received grants from the National Endowment for the Arts for their performance art. And then, let's say, the National Endowment for the Arts decided to award them grants. That was then leaked to a conservative columnist for the Washington Post, who wrote a column about how the art, U.S. taxpayer dollars were going to go to fund these gay and lesbian performance artists, one of whom performed in the nude, and the money was pulled back from them on the ground, that was just too politically controversial. And I represented them in suing the government to say, if you made a decision on artistic grounds to support them, you can't take the money back on the ground that they're politically controversial. And we won that case. We eventually, we got their grants back. We did not succeed in challenging the law under which that was done, but we did get them their grants back. But the very fact that they had been singled out for this censorship made them household names. They never were more popular. They were selling out everywhere they went. They were, totally in demand. Why? Because the government was trying to suppress what they said, because it didn't like what they said. So there's a real, I think, sense in which, when you do this, you make these folks martyrs. You give them more of a platform than if you just let it go, tolerated it, criticized it, responded to it with more speech, and the like. So those are I think are the arguments. That's why those are arguments why I think it makes sense to and then I'll just throw out one other, which is, how in the world do you define hate speech? How do you define hate speech? An epithet, a racist epithet, you know, the most common racist epithet in the United States. I think everyone knows what it is. Is that hate speech? Well, you know, we've sort of culturally, without a hate speech law, we have culturally extirpated the language, the language, at least in, you know, polite company or any real, you know, almost any civilized company of that word. People do not use that word. People do not use that word without a law, except those who do. And the most common, you know, folks who do, and do so all the time, you know, are African-American rappers and African-American kids who, you know, use it, you know, to talk to each other. So, you know, so is it hate speech when they use it? Is it hate speech only when a white person uses it? Is it hate speech, you know, when a black rapper uses it, but when a white rapper sings the exact same song, it's hate speech? How do you define hate speech? Even with respect to something that seems like it's a kind of an easy case, a racial epithet. But then it gets harder, right? Because if what you're really concerned with respect to hate speech is, you know, undermining the equality and dignity of other human beings, silencing, you know, members of minority groups, arguably much more effective ways to demean the integrity and humanity and dignity of members of minority groups, much more effective ways of silencing them are making very powerful rational arguments against their views, against affirmative action, for example, or arguments about the, you know, the incidence of criminal activity in the inner city minority communities. Those can be very hurtful. They can be very demeaning. They can be stereotype, you know, they support stereotypes. They can silence. They can make people feel really, really terrible. They can do harm, you know, in that sense. But, you know, if you call that hate speech, well, now you have cut off even rational dialogue and debate about facts that are uncomfortable in the world. So there's this definitional problem, right? The other arguments I made really don't turn on what, even if you could define hate speech clearly, you would have arguments, you know, you shouldn't give the government that power. It's counterproductive. It's important to teach tolerance. But when you add to that, it's really hard to define hate in a way that is not too broad or too narrow or too likely to be arbitrarily applied. That's another reason why I think we're skeptical about the effort to regulate hate speech. You know, the arguments that I most often hear on the other side is that, you know, it's equality versus speech. That's one. That this speech, you know, tolerating the speech has a real cost to the values of equality. And why should we favor speech over equality? And then the second argument that I hear is that it's one person's speech over another person's speech, because, you know, allowing people to engage in hate speech silences other people, members of the targeted groups. And so you are favoring one side's speech over the other. You are silencing, allowing a group to be silenced, and you shouldn't do that. So you know, with respect to the equality argument, you know, I would concede that some hate speech undermines interests in equality. Um, but that's true of speech with respect to all other values. There is speech that undermines democracy. Some of your president's speech, some of our former president's speech, I think could very well be argued that it undermines the democratic system that we rely upon. Definitely harmful. But should we suppress it because we've concluded that it undermines democracy? Should we suppress? I think once you know, in our system anyway, the Constitution constrains the government. Doesn't constrain private individuals. Private individuals have constitutional rights. The government is constrained by the Constitution. So when a private individual engages in speech that undermines equality interest on the other side, it's not a constitutional equality interest because it's not the government speaking. And then I think also the argument about equality proves too much, in the sense that I think pretty much every constitutional right furthers inequality in one way or another. I mean, the most obvious is the right to hold property. That is by far the single most powerful right in furthering inequality. The right of privacy is a right that people with money can exercise, people who have the resources to surround themselves so that they are in private, but other people can't. That the wealthy use to you know, against those without power. So you know, I think you know, there are a number of responses to the equality argument. To me, the most powerful response is we should regulate laws and practices that that discriminate, conduct that fails to treat people equally. But the equation of conduct with speech is exactly the step that was taken that made it possible for us to have, you know, the excesses of the McCarthy era, and the insistence in our law on separating speech from conduct is sort of at the core of what our First Amendment protects, and so to the extent that there's conduct that causes inequality, yeah, we should respond. And to the but if it's just speech, it's a cost. Just as, you know, it's a cost to the First Amendment that we have to tolerate people who advocate against the democratic system, even though that's sort of at the core of it. And then on the silencing point, you know, the silencing point, I think, is to me is a kind of a paradoxical argument, because the argument is this speaker is silencing this speaker by what he says. So let's silence this speaker, right? Let's take sides and silence one of the speakers. In the name of avoiding the silencing of speakers, you are authorizing the state to silence speakers. And that seems to me to be problematic as a move. You know, and then the last thing I'll say is that to me, the history of sort of political progress in the United States has been a history of using the First Amendment. Women, slaves, African Americans, LGBT folks, indigenous people, immigrants, people with disabilities. I mean, this is who we fight for at the ACLU every day. How do they fight for themselves? And how do we fight for them? Through speech, through association, through assembly, through the exercise of First Amendment freedoms. That is the way, I think, if you look at history, that is the way that marginalized groups, subordinated groups, discriminated against groups have made progress in this country. They have not made progress by relying on those in power, relying on the majority, relying on the status quo, relying on the powerful to regulate what is said. That is not, you know, I don't see any evidence, and I don't see any evidence in other countries that the regulation of hate speech has advanced the ball in terms of racial equality, has done much of anything to diminish racial tensions or racial subordination in countries that have these laws. So I do have a question. Not only do I think there's a real counterproductive risk that you kind of make martyrs of the people you target, but even if you don't make martyrs, it's not clear to me that that this is the way, the tool for marginalized groups to advance in society. I think quite the opposite. The tool for marginalized groups to advance in society is a free, robust marketplace concept in which the government does not have the power. Those in power, the majority, does not have the power to say your speech is out of bounds. So all of that said, obviously, reasonable people can differ. Obviously, you can have a democracy and have regulation of hate speech. I'm not suggesting that, they're inconsistent. I'm just trying to set forth what I think are the most, are the reasons that we've come to the choice that we've come to in this country, and why I personally believe it's the right choice. But happy to take your questions and comments. And
thank you very much, David, for your very thoughtful, full of ideas speech. I'll open the floor for those who are in the classroom. If you want to make a question, or you have Clarissa, and then Gabriel, and then Mateus. Okay, Clarissa.
Good morning, everyone. Good morning, Professor Cole. Thank you very much for this opportunity to listen to you, to learn with you. It's a real honor to have you here with us today. Well, I have a question. I have a question related to one of the reasons or the grounds that, from what I understood, you advanced as a justification for the United States, the American model. So I understood, and if I didn't understand correctly, please correct me, but I understood that you said that The Constitution imposes duties on the government, and that individuals have rights protected by the Constitution. So, for example, equality duties would be duties imposed on the government and not equally imposed on the individuals. And related to that, speech rights would be then costs that a constitutional democracy would have to bear. That would be related to the fact that individuals don't have equality duties as the government has. But from what I understand, not all kinds of speech are equally protected, even in the United States. So you have room for prohibiting libel, or you have room for regulating in a different way commercial speech. So is there an argument to differentiate between these kinds of speech and hate speech? Why the American democracy would have to bear the costs of hate speech, but it decides not to bear other costs related to other kinds of speech that it considers to be legitimately regulated?
Yeah, no, that's a great question. And I don't mean to suggest on the Constitution. Whoop, what happened? Oh, shoot. Sorry. Sorry, I just knocked over my mouse and now I can't see you. I think you can probably still see me, but one sec. Oh. Okay. Sorry, why can't I get this?
We listen to you well.
Yeah, okay. Well, I'm just, I for some reason, I'm not, and now I only see you as a little, very little. So I don't mean to suggest that the fact that the Constitution only regulates the state does a tremendous amount of work in the argument. It's just to say that, you know, when the state acts against an individual, the Constitution is implicated. When an individual acts against another individual, the Constitution itself is not implicated. That doesn't mean that there can't be really important interests implicated. And so, for example, you know, we make it illegal to discriminate for private employers to discriminate on the basis of race in hiring. Right, so we can choose to impose equality duties on individuals, and we do. Now, and in that context, we include in the definition of discrimination some forms of speech, speech that, you know, is so severe or pervasive that it creates a hostile work environment, for example, is actionable, consistent with the First Amendment. So it's not an absolute position that we take. With respect to you know, the fact that there are other kinds of speech that the First Amendment does not protect, that's true, and I think each one of them has to be sort of defended on their own grounds. You know, no right is absolute. We don't suggest that the First Amendment is absolute. You can punish someone for speech when they are inciting violence and satisfy that very rigorous standard in Brandenburg. You can punish someone when they engage in libel, but the First Amendment protections around libel are such that it is very, very hard to prevail in a libel action against another individual, because we have, again, sought to define the offense very narrowly, impose very significant burdens on the person who is bringing the lawsuit, because we think basically people should be free to say things about other people, and that if we have the government determining what is truth and what is not truth, that is a dangerous thing. Commercial speech, different set of arguments are made there. I mean, the arguments there are that that commercial speech is not so central to the democratic process. Commercial speech, sort of traditionally defined, is speech that proposes an economic transaction. It is it is regulated. It's sort of it is part of the economic transaction, and so the need for government regulation of the market, combined with the fact that telling someone how much toothpaste costs or how much alcohol is in a can of beer, is not central to political discussion, and is also not susceptible to political manipulation in the same way as things like hate and incitement and the like are. So I think you just have, I mean, we also don't, at least in theory, we don't protect obscenity. We don't protect true threats. So yeah, you can say, well, look, you don't protect everything, therefore, why do you protect hate speech? I would say we protect most things, so why shouldn't we protect hate speech? What are the compelling arguments that justify treating hate speech different from, incitement to violence? Right? Why would we, if we don't allow the state to regulate incitement to violence, except where it is likely and intended to produce imminent lawless action, and we would also permit the regulation of hate speech if it was intended and likely to cause imminent lawless action against a person because of his race. But if we don't, but beyond that, why should we treat hate differently from all kinds of other really noxious ideas and dangerous doctrines that we nonetheless tolerate?
Okay, Gabriel?
Professor, sorry, I didn't have a question, just was clapping. Didn't raise hand, but thank you.
Mateus? Mateus?
Hello. So Leonardo is on the queue. If he can speak, then I can ask my question.
Okay, so Leonardo, you have the word.
Thank you, Professor Cole, for the talk. It was very, very interesting. I have a question about fake news, which is a very interesting topic in Brazilian law nowadays. And normally we hear a number of arguments for regulating fake news and prohibiting fake news, and these arguments normally have some kind of supposed background on the US law. So we hear that free speech is all about the debates of ideas, and sometimes we even hear justice from our Supreme Court arguing that that would come from Justice Holmes' marketplace metaphor, and so that as long as someone was exposing ideas, there would be protection for the speech, as opposed to someone who is saying something that is false. And when someone said something false, the speech could be curtailed. And I understand that your talk is about hate speech, but here we sometimes cross a boundary towards speech that harms democracy. So that's when the thing gets a little bit complicated, because sometimes, and I'm sure that you Americans had some issues like that before, politicians in Brazil, right-wing politicians, are questioning the reliability of elections. So that would be the fake news that damages democracy. And I think that something that is behind this kind of argument in Brazil that is sometimes foreign to the US way of thinking free speech, at least in the mainstream First Amendment scholarship, is that any kind of rights that we have, any kind of exercise of rights that we have are supposed to contribute to some kind of public good, so that obnoxious or dangerous here is that we will provide some kind of authority to discriminate between falsehood and truthful speech. And I think that we can argue that in Brazil, this kind of legal weapon is being handled in a manner which is not consistent with the rule of law. So my question is, how would you, as ACLU person, deal with this kind of argument in the US setting? So how would you argue against or for this kind of legal weapon where the state could discriminate between lawful and unlawful speech through false or truthful speech?
Yeah.
And I recall a number of cases in the US law where falsehood has been granted not that kind of protection that normal speech or truthful speech, but at least some kind of protection. You know, New York Times versus Sullivan, there were a number of mistakes made, then they were nevertheless protected, and there was a reason for that. So how would you deal with this kind of argument were it put forward to you?
So there's a lot in that question. Thank you for that question. There's a lot in there. You know, I think, you know, it's true in New York Times versus Sullivan, there were false statements made, but what the court said was you have to, unless you're going to sort of give people the power to use the state to suppress legitimate debate, you have to limit libel, which was in that instance, to speech that is the speaker knows is false, or is recklessly disregards the fact that it's false. Very, very hard to prove, but the reason for that is, I think, shown by New York Times versus Sullivan. What was that? What was behind the suit against you know, those folks? It was that they were ultimately challenging Southern police abuse against civil rights demonstrators, and they may not have gotten some of the details right, but you know, the overall debate about Southern police abuse of civil rights demonstrators during the 60s was very important. And if every time you made a claim about police abuse, you could be sued if you made a mistake, it would really suppress people bringing those claims. And I think that's the same thing is true with respect to fake news. I think fake news is a problem. I think social media has really, you know, changed the kind of you know, the ecosphere for it's an echo chamber, but it's also an echo sphere of speech, and, you know, in ways that make fake news much more dangerous. You know, people posting things saying that polling places are closed when they're open. You know, there is zero value to that speech. It causes real harm in the moment. And certainly, you know, Facebook should be able to take it down. Private entities should be able to choose not to, you know, further propagation of fake news. You know, the fact that there are centralized authorities that have, you know, private centralized authorities that exercise that power is of concern to us. But there may be other ways to deal with that than through government regulation. I don't think but take like the reliability of elections. You know, so imagine you gave the government the power to make it a crime to falsely criticize the reliability of elections. You know, there are a lot of times when those in power might very much want to stay in power, might very much be inclined to, skew the electoral process. And it's critically important that people be free to say, hey, you've screwed with the electoral process. You've suppressed my right to vote. You've closed these polls and not these polls. That's criticism of the reliability of the electoral process. But if you're going to protect that, how do you protect that from government censorship without protecting also, false assertions of the unreliability of elections? So I just think it's I don't think it's a good idea to give the government the power to determine what is true or false. I mean, in the United States, libel law turns on truth or falsity, but it doesn't turn only on truth or falsity. There also has to be a reputational harm involved. And so when you just have falsity, we had a case called United States versus Alvarez, where somebody lied about getting a kind of honorable discharge or something, or a Medal of Honor during the Vietnam War. He lied about it, and we had a federal law that made it a crime to lie about getting military honors. And you could understand why you'd want to make it a lie, because it cheapens military honors if you let people lie about it. But the court said, you got to protect that. You can't have the government deciding, who's telling the truth and who's not telling the truth. We are going to protect even intentional lies where they are not connected to some concrete injury. And so reputational injury, well, then we look at truth or falsity, not only at truth or falsity, but truth or falsity. Fraud, well, then we look at truth or falsity. If you use a false statement in order to induce someone to engage in a fraudulent transaction, but that's, then it's part of the fraud. But standing alone, lying, is protected by the First Amendment to the Constitution.
Okay, thank you. Mateus?
Hello, thank you, Mr. Cole, for your time. So my question is about social media. So social media is not bound by the First Amendment, and therefore tech giants like Facebook or Twitter can choose who can and who cannot express themselves on their platform. So seeing that social media has become one of the main, if not the main avenue of public discourse, some people are putting forward the argument that social media should be considered public utility. And therefore, some argue that the time has come to extend the reach of the First Amendment to cover these powerful private entities. So what is your personal opinion on the question if speech on social media should be covered by the First Amendment protection?
So that is a great question. It is a huge question. You could teach an entire course on that question. Sort of how does social media change how we think about free expression, about the First Amendment, about governmental power, about private power. I mean, it is very, very rich, very, very rich, very, very challenging. I guess I would say a number of things. One is, what does it mean to say social media is a public utility? So one thing that it might mean is the government should be able to regulate social media the way it regulates like common carriers, the telephone company, the electric company. These are entities that have to serve everyone without discrimination, period. Right? You have to let, if you're the phone company, you have to let, people make phone calls, even if they're, spewing hate, even if they're spewing lies, even if they're doing, whatever. You just have to, right? You can't discriminate on the basis of content. Do we want that? I think a lot of people are concerned that social media is in some sense too free, and it has become too easy for anyone to publish falsehoods, harmful statements, and the like. And we need more regulation, right? I mean, anyway, Facebook, Twitter, all of these kind of social media platforms are under pressure to regulate, not to free up, but to regulate. That's the pressure they feel, not to free up, to regulate. Now, if you made them a public utility, if you made them, you sort of treated them as the government and treated them as subject to the First Amendment, like the government is subject to the First Amendment, then they'd have less power to regulate that speech. Not sure that's necessarily what we want. I sometimes think that we're at the beginning of this process. We haven't yet developed a set of norms for social media and for social media platforms. Norms may be the best way to deal with these issues. I mean, if you think about the press, the press has lots of problems too. The press can engage and can put out fake news. The press can, skew the marketplace. The press can do this, the other thing. But we don't allow the government to regulate the press as such, for the most part, right? We say hands off because the press is critical to checking the government. But what we have developed is a set of norms in the press that, objectivity. I mean, they're obviously critiquable and hard to achieve, but there is some notion of some effort to sort of present the truth, to do fact checking, to not to just blatantly lie. That is not true, right, for individuals on social media at all. And so what should the norms be for social media platforms? Should they be in the business of trying to clean up the worst stuff, which now Facebook is trying to do, or should they be totally hands off in the way the government is? Or and then you have a problem of the fact that Facebook and Twitter just exercise so much power. Instagram, they exercise so much power. The same reasons that we have concern, not the same, but similar reasons to our concerns about giving the government the power to say what is truth and what is falsity, apply to giving a single private entity the power to say what is true and what is false, what shall be said and what shall not be said. How do you respond to that concern without empowering government, which creates the same or worse problems? Some people have suggested antitrust. Some people have suggested breaking up these entities so that there are multiple entities and there are, no one of them has such power. That might work. I don't know whether, technologically, whether that would work, given the kind of, the way in which the social media depends upon kind of everyone being on the same page. But so I think there's a great article by Tim Wu, who teaches at Columbia, called, is the First Amendment, irrelevant in the social media age, or something like that. That's not the exact title, but it's, a short article, but it just sort of goes through how the advent of social media has really upended a lot of the kinds of fundamental faiths that we proceeded on with respect to how we think about free speech. And I think that's true. I don't think anyone has the answers right now to how how we ought to best adapt to this reality, but we have to, because it's a reality. It's not going away. I think, for example, one example is with obscenity. For a long time, there was such a thing as obscenity law in the United States. There was such a thing as obscenity prosecutions. There was such a thing as censorship of, I always thought it was kind of silly, but it was part of our, our law. The internet and social media, well, more the internet than social media, but the internet basically blew that out of the water. there's so much sex in so many, so everywhere on the internet that it's basically impossible to regulate. And so it doesn't happen. Child porn is the only thing that really gets regulated now. So that's a context in which social media basically just made the law irrelevant. And I think there's ways in which social media, I don't think it makes the First Amendment law irrelevant, but it really challenges in fundamental ways how we ought to think about free speech in a very different, very different context.
David, I'd like to jump into what you have just said about obscenity. I was wondering if, as far as obscenity is concerned, and the fact that there's a lot of pornography all around that made the obscenity law useless, as you mentioned. I wonder if you think that there's still some kind of contradiction at the jurisprudential level between acknowledging that obscenity is a speech with non-value,
yeah,
and pornography is something that is protected. This is my first question.
Yeah.
Let me add a second one, which is, how universal do you think that the American model is? I mean, you stressed many very pragmatic arguments concerning the fact that American history showed that First Amendment jurisprudence is useful, is protective. So I wonder, how universal is this? How do you think that, for example, the UK's experience is really a threat for freedom of speech? I mean, how is the European experience really threatening freedom of speech?
Yeah. So two great questions. Obscenity and pornography. I guess my view is that the law that justified the regulation of obscenity was inherently inherently contradictory, could never be squared with First Amendment values in the first place. I mean, the whole idea is this speech is so offensive to people that we should be able to suppress it. Whereas the kind of the core cases in the First Amendment doctrine, the flag burning case, or the case Cohen versus California, the case that protects someone who wore a jacket into court that said "fuck the draft," right? The core principle of those cases is the fact that speech offends the majority is a reason to protect it under the First Amendment, not a reason to suppress it. So I think obscenity law itself is sort of internally contradictory to begin with. The only real, justification for obscenity law that has any, integrity is the historical one, which is, it doesn't have any philosophical integrity, but if the First Amendment was designed to protect those things, those forms of expression that were protected at the time that the First Amendment was adopted, obscenity was excluded. And so it was just never intended to be protected. If you're a historical, originalist, that's an argument at least. But from a principled standpoint, I don't think obscenity is you can really justify the regulation of obscenity under First Amendment grounds. Pornography, even worse. The pornography, the sort of anti-pornography ordinance that was struck down in the case that I gave your students to read, was expressly designed to suppress the speech because it expressed a certain message about women, that women are, objects of, they're objectified as objects, or, of sexual interest, or, that is like as limitless as, look at the pages of any magazine, look at the advertisements for any women's clothing. I mean, it's like, where do you draw the line? Where do you draw the line? And it is clearly about suppressing a particular viewpoint. And I think one of the most core principles of the First Amendment is that the government should not be taking sides on disputes, on views. It's not saying a particular subject is off limits, it's saying particular messages about a subject are off limits. So I think pornography and obscenity are equally, should not be regulated under the First Amendment. As I say, it's basically academic now because the technology has beaten any government efforts to regulate. The first, on your second question about, I don't claim that the American, experience is universal by any means. I'm really giving an explanation for where we come from, why we come from it. I think every society learns from its own experiences. So, I want to be modest about those claims. I do think, though, that it's not just a historically contingent fact that, a robust, that robust First Amendment protections are critical to democracy. And, I think you see that in every country where some, authoritarian or, populist leader has come to power, by who they target. They target the people and the institutions that are protected by the First Amendment, the academy, the nonprofit sector, the press, right? I mean, these are all, places where people are able to come together to push for change, to advocate against the government, to be a watchdog on the government. And they are instantiations of the First Amendment. So in that sense, I do think that democracy depends upon substantial skepticism about government power to control speech on the ground that the speech is harmful. And that's really what the hate speech regulation serves. But as I said, look, a democracy, UK is a democracy. The EU is, most of the countries in the EU are democracies. Some are more fragile than others. I don't think any of them have as free speech culture as we do, but do I think that they're therefore not democracies? No.
Okay. Well, we have a question from the YouTube. So before coming back to our classroom, let me read this question from Arthur Sadami. Professor, I'd like to know your thoughts on the thesis that we could indirectly regulate the spread of hate speech and fake news through a structural litigation mechanisms over specific players, mainly big techs by means of antitrust policy. This movement seems to be recently followed by the FTC's new administration under Lina Khan's term. This movement, in my view, can be verified through the recent developments of American antitrust policy over big techs, since they are expanding the concept of harm to encompass the spread of misinformation, hate speech. So he wants to.
Yeah. So I think I think that's yeah, absolutely. I mean, this is one way of dealing with the problems that social media presents, is by trying to break up the concentrated power that the tech giants exercise in this forum. It's a critically important forum, maybe the most critically important forum for the exchange of ideas, and having a handful of actors in control of that forum poses real risks to to our democracy and to the health of our debate, etc. And so, breaking them up, making them less powerful, making them, having more voices and more editors, really more editors, because there's millions of voices no matter what. It's really about the editors. Having more editors, is a step in that direction. It's not an answer necessarily. I mean, you still then have the question of what should those editors do? What's the right thing for an editor to do? Is the right thing to take down Trump's Twitter feed, or is the right thing to, keep it up because even though it's noxious and hateful and horrible, it's of serious public interest and therefore should be maintained? I don't know. I don't know. I think an argument could certainly be made that there's a real risk if Twitter and Facebook have the power to silence anybody whose views they disapprove of, and that's a real threat when they exercise as much power as they have. And so the best way of one way of dealing with that is to break up the power that they exercise. And I think the FTC is trying that. Whether they'll succeed, is another matter entirely. Our antitrust law, would have to evolve. These are going to be. There is a lawsuit against Google, but it's these lawsuits are very, very challenging, and the tech giants have the resources to hire the very, very best lawyers. So we'll see. But I'm generally, I think, I haven't come to any particular, settled views on these, but I'm generally thankful that we have someone like Lina Khan at the FTC really asking these questions and pushing against the power of the tech giants. And Tim Wu, the same, and the guy I referred to earlier, Columbia law professor, but he's now in the White House dealing with policy regarding the internet and the tech world.
Okay, Iago, and then Clarissa.
First of all, I would like to ask you about maybe a possible shift that's been perceived in the public opinion in the US regarding the possibility of restricting speech, especially in the cases of hate speech and pornography. I think it is well illustrated in one of your texts at the New York Review of Books, in which you cite a poll, which was made in 2015, I believe, which showed like 40% of millennials were pro the possibility of restricting speech on those terms. So first, I would like to ask how relevant you think this change is, if it is really a shift that is happening and it's widespread, or it's something very concentrated on like educated young people or at universities or something like that. Second, how do you perceive that through your action at the ACLU? Do you think this changes anything? Because I've also read that there's sometimes not a conflict of interest, but sometimes what is perceived as a conflict of interest for the ACLU, because you represent LGBT communities, you represent Black communities, you represent all of that, but you also represent people marching at Charlottesville, for example. So how do you perceive that in your advocacy for free speech and other civil liberties, and also how do you perceive that as a whole in the US political context? And finally, sorry, just to complement, if you think there is a possibility that maybe these elements, if they are really relevant, could I don't know, impact somehow a change in either legislature or and if that legislature that I think would maybe get more support from the more conservative now Supreme Court. Sorry, I know it was a very long question, but
yeah, no, but a good question. I think I'm very concerned that that poll and others suggest that young people are less, sort of supportive of the value of tolerating that with which they disagree. I think that's a real challenge. It's a challenge to the ACLU. It's a challenge to our democracy. I think we need to convince young people that that these values are important for the reasons that they are important. And I think that it comes out of a sort of being, the battles that were fought for First Amendment rights were pitched battles, but they were pretty much won by the sort of 1970s. And so people, young people today grew up, it's like, women who grow up after the fight for women's rights and just assume, oh, of course, women have always been treated equally, et cetera. And, if they take it for granted, I think people can have a tendency to take for granted the protection of speech and then not value it as much as those who sort of lived through or grew up learning about the history of government targeting of dissidents and dissenters. And I saw, I think in some ways the First Amendment is a victim of its own success in that regard. And we see that within the ACLU too. I mean, there's a kind of, the ACLU is a big, we have about 2,000 employees across the country, and they are, some people come to the ACLU to do voting rights. Some people come to the ACLU to do racial justice. Some people come to the ACLU to do First Amendment, so not everybody comes with the same set of values. So it's not, it's hardly surprising that there's disagreement within the ACLU. But I think that certainly the leadership of the ACLU, I'm part of the leadership, the board is the, ultimately guides the ACLU, is committed to the idea that, part of who we are is, a core part of who we are is protecting speech, including protecting the speech of those who we are fighting against day to day, on issues of racial justice, LGBT rights, and the like, and that we can do both. We always have done both. We can continue to do both. As in the same, when we were defending the Klan and, in Brandenburg versus Ohio, we were also, challenging racial segregation across this country, and you can do both, and we'll continue to do both.
I hope we will still have time for two more questions.
If they're quick questions, but I have to, because I have another appointment to go to. But why don't we take two questions and I'll try to answer both in one.
Okay, wonderful. So Clarissa, and then Leonardo, and then a final speech from David.
Thank you again. I'll try to be quick. I want to go back to Leonardo's question on the status of falsity in the US law. From what I understood, the difficulty of penalizing a false speech doesn't necessarily lies on the difficulty of showing that it is false. So you gave examples on how it is sometimes difficult to penalize false speech because you can't show that it caused harm, or you have to know that the speech was false. So I understood that there is room for prohibiting some kind of falsity if you can connect it to other reasons to prohibit it. So my question is, do you think there is room, or do you think there are good reasons to differentiate between the responsibilities or duties of public authorities when it comes to the truth or the falsity of their statements, and the duties and responsibilities of the common citizen? Would it make sense to regulate more strictly what public authorities say on the basis of its truth or falsity than in comparison to what common citizens say? And I have some examples in mind. For example, some public authorities in Brazil statements on vaccines in the COVID context, or medical treatments related to COVID infections? So that's the question.
Yeah.
And Leonardo, we can take your question.
Professor, I've been reading your pieces at the New York Review of Books, and my question is, correct me if I'm mistaken, but you defended the view that the custom-made cake was not expressive. And correct if I'm wrong, but I'd like to know where you would draw the line between expressive and non-expressive conducts in these cases where anti-discrimination ordinances, in the view of some people, curtail free speech. Thank you.
Great. So on government speech versus private speech, yeah, I mean, I think government speakers as speakers have certain responsibilities, and you know, don't have the same kind of freedom that citizens have. You know, so you know, for example, if the press secretary, you know, the president's press secretary came out and said something that was contrary to what the, you know, said something that President Biden approves of X, and in fact President Biden didn't approve of X, you know, they could be fired. Yeah, even though a private citizen who said President Biden approves of X, even though he didn't approve of X, could not be punished. So I do think there are greater, you know, responsibilities can be imposed on government officials given their power. You know, I think there are issues about who's going to enforce those, and do you trust the enforcers versus the speakers, et cetera. Those are going to be issues, but I do think you can draw some distinctions between someone who's speaking as a public official in his capacity or her capacity as a public official versus people who are speaking in their private capacity and impose greater obligations on the former. With respect to the cake shop, no, I did not take the position that the cake. I represented the couple in the gay couple that was denied the cake in Masterpiece Cake Shop. But our argument was not that the cake wasn't expressive. Our argument was that it doesn't matter whether the cake is expressive. That what you should ask about when you're asking whether the anti-discrimination law at issue, which was a law that says if you go into business to the public, you have to serve the public, and you can't discriminate among members of the public based on, you know, sex, race, sexual orientation, and the like. Is that law targeted at the expression of this cake, or is that law targeted at the conduct of servicing the public? And if it's targeted at the expression, if the law said you can't sell things that express anti-gay views, that would have to satisfy strict First Amendment scrutiny. But that's not what the law said. The law said you can't discriminate in your conduct on who you serve. And that law applied to every business. It applied whether you were selling books, which are obviously expressive, or whether you're selling, you know, hammers and nails, which are not expressive, right? The same law applied in the same way. And therefore, the law was not about speech at all. And the fact that it regulated speech businesses or expressive businesses in the same way as it regulated other businesses didn't mean it had to satisfy any kind of heightened First Amendment scrutiny. And I think the court basically accepted that at the theoretical level. It said the fact that a business has philosophical or religious objections to, you know, an anti-discrimination ordinance does not allow them to, you know, get out of complying with that ordinance. And if you listen to the argument, you'll see that, you know, the other side was, you know, could not answer the following question. If your principle is that expressive businesses don't have to follow anti-discrimination law, how do you define what's an expressive business? Maybe this cake is expressive, but what about a nail salon? What about a restaurant? What about a chef? What about a beauty parlor? Aren't they all expressive? I mean, to some degree, almost anything can be characterized as expressive. Any conduct can be characterized as expressive. So it doesn't really work. And I think it's the wrong question. You don't ask, is the conduct expressive? You ask, is the government regulating the conduct because of what it expresses, in which case it should be treated as a First Amendment problem, or is it regulating it because of its conduct irrespective of whatever it communicates, in which case it shouldn't be a First Amendment problem.
So the impact was incidental, right? So
yeah, exactly, incidental. It's only incidental, and that's not enough to, that's enough to trigger what we call intermediate scrutiny, but the government basically always wins under intermediate scrutiny. So
other business would be, in your view,
same
under the same situation, like
yeah.
If you a tailor, for instance.
Yep, tailor. If you choose to serve the public, you don't have to choose to serve the public. There are lots of, I write freelance. I don't serve the public. I write for who I want to write for, and only artists. Lots of artists. They don't serve the public. They make their art and then they sell it. They don't. They choose who they're going to draw pictures of, etc. But if once you sort of go into business for the public, you've made that choice. You've made the choice to access the public market. You have to accept the rules of the public market, which are that you don't discriminate.
And same thing with those people that say that you not wearing a mask is an expressive conduct, as if as we could say, it's not the point about we are not trying to suppress your message. The consequences for speech are indirect. It's not the speech itself which is being. Yeah. The key, I think, is to ask, don't get caught up in, is the conduct expressive? Because almost any conduct can be expressive, right? I move my hand like this, that's expressive, right? It's conduct and it's expressive. There's, when I move my mouth and it's expressive, right? Conduct. So it's like, that's not the way to ask the question. Ask, what is the government's interest in regulating? If the government's interest in regulating is what the conduct expresses, flag burning, for example, then you have to subject to First Amendment scrutiny, but if strict First Amendment scrutiny. But if the government's interest is in regulating the conduct across the board, regardless of whether it communicates anything, then you subject it to much lower scrutiny, and it's generally going to be acceptable. I think in the United States, Texas versus Johnson, flag burning, strict scrutiny because it's targeted at the message of flag burning, and United States versus O'Brien, draft card burning, intermediate scrutiny because that law basically made it a crime to destroy your draft card, regardless of whether you destroyed it in public or in private, whether you did it in a way that expressed a message or whether you did it in a way that nobody saw. It was about preserving these draft cards, not about suppressing the message, or at least that's what they said. And that's a key distinction. Thank you.
Well, David, I don't want to abuse of your extreme generosity. I just would like to thank you very much. It was really a lot of food for thought for us. Thank you very much. We hope we can have you in another opportunity. It has been an honor and a pleasure to listen to you.
Well, thank you for so many great, really, really thoughtful and difficult questions, and for engaging, so civilly on such a difficult subject. And delightful to see you again, Ronaldo.
Okay, see you. Thank you again. Bye-bye.